This law since 1977. He's a former Denver district attorney. He worked in private practice for some time, and he's been with attorney regulations since 1992. Jamie lectures frequently. He actually developed, designed the Colorado Trust Ethics course, Trust School. And he also lectures frequently and has taught at the University of Denver. So Jamie's going to talk with us a little bit about all of the ethical issues that we get involved with as GALs and touch upon some of these land issues as well. So thank you so much, Jamie.
Thank you very much. Well, you notice I brought my book with the rules in it because I never leave home without it. Who knows what will come up today. I must say that I've been learning a lot about water law lately, not because of an investigation. I've been learning a lot about the Colorado River. And you know, it serves 40 million people with water. And it's an extremely complicated water system if you don't know that already. But 40 million people is a lot of people to serve with water. It's very complex. Water law is very complex. And getting ready for this presentation, this is like I think the second or third or maybe the fourth presentation I've done to your group or to other groups like this, it dawned on me that what you do may be now more complex than water law. And I'm a little bit daunted by the complexity in our life today, but you are getting through it, I hope, and making your way through the maze of ethical turns and twists. And I won't have all the answers for you today about what you can and cannot do. And it seems like I attended the first afternoon session and then the second one, and it seems like that's sort of the theme. And there are no bright line answers as to what you do in certain situations. But of course, the bright line certainly gets a lot more murky when, let's imagine you are a GAL in a case, and you represent a client, the best interests here, and you're sitting in counsel's chair, and then theoretically, best interest is sitting in another chair, and then all of a sudden you get the land decision, and you've got a privilege holder sitting in the third chair, and maybe you're that privilege holder sitting in that chair also. It boggles the mind, the sort of existential types of philosophical, metaphysical issues you all deal with. I'm not so sure many other lawyers deal with those differing roles that you might play at the same time. But so I understand, I think I understand some of your problems, and I hope to at least give you some minimal guidance how to work through them. So one of the things I was asked to talk about a lot today was the land decision, and what ethical dilemmas does it bring up for you if you don't already know them. And so I'll try to do that. And at the same time, if you have any questions, raise your hand while we're going on. I think we'll have plenty of time to cover what I have prepared for. Unique ethical challenges in representing children and their best interests. So let's move on to the next slide. This rule, it seems to me, has come up a lot this afternoon, but hasn't really been explored. We've been talking about, you know, attorney-client privilege, patient-physician privilege, psychologist-client privilege. We've been talking about those privileges, but in the background is this rule of professional conduct 1.6 that I think you all have to keep in mind. And that rule is very, very broad. It's much broader than any statutory privilege. What do I mean by that? Well, it's much easier to talk about in the context of a regular attorney-client relationship than it is, say, perhaps GAL and best interests of the child relationship. But let's take a moment just to read the rule. A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent or the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B, which I'll get to in a moment here. But so the first thing you should recognize is that this is a huge area of information. And it's not just communications that a lawyer has with their client. It's not just the notes that a doctor has with a patient. This confidentiality rule would be about as big as the screen here, and the attorney-client privilege or the doctor-patient privilege might take up the area of the period after the last parentheses, if we wanted to do a Venn diagram. In other words, confidentiality, your obligation to your client of confidentiality is huge. And notice that the duty here of confidentiality is confidentiality of anything you learn during the representation, right? And it doesn't end, it doesn't terminate with the termination of the representation. And that may come up in your practice as a GAL or a respondent's parent counsel. That may come up, that the representation is terminated and you wonder, well, I'm getting asked for information from somebody else. Does the representation being terminated have an effect on confidentiality? No, it does not. So keep that in mind. And keep in mind how big the duty of confidentiality is. Now, let's put this in the context of a GAL who's representing the best interest of the child. Now, there's no, you can't get informed consent. Well, you can theoretically, metaphysically, get informed consent from the best interests of the client, right? You sit the client down, that's you, right? It's so strange. It's like a Gestalt therapy, right? You have two chairs in your office, one for you as the best interest of the client and one for you as the attorney for the client. And you ask yourself, well, is it okay to reveal this information? And you come to the decision, yes, it is. But this is what goes on in your head, right? Absolutely. This is what you do. However, put that funny example to the side, or that funny little experiment to the side. The decision to reveal information that you learn during the representation of the best interest of the child, it seems to me, is not such an easy decision. I think you have to make a decision, is this really in the best interest of the child that what I learned during the representation should be revealed? I don't think that's an easy answer to come to. And in fact, if we go to the land decision, and I am not trying to make any example of anybody who may or may not be in this room, but the GAL in that case made a decision to release the doctor's report. That is information that the GAL learned during the scope of the representation, So that immediately brings up the question of 1.6. And was that a good release or disclosure of information under 1.6? I don't really think the court went into a discussion of that, and nor can I, because I really don't know. I don't know. I have no idea if it is, but that's the issue that was involved, is can I release this information? Is it in the best interest of my client, the best interest of the child, to disclose that, to essentially disclose something that's privileged, or not privileged, but that's confidential under 1.6? That's something I think you have to keep in mind. And I think that also you have to keep that in mind in terms of what Justice Rice wrote in Land. And my understanding of her words in that is that the disclosure or the waiver of privilege may be limited. It may be. And so if it is limited, then I think you have to ask yourselves about the scope of your waiver and the scope of your disclosure of confidential information. Now, Justice Rice isn't talking about a Rule 1.6 analysis of the GAL in the Land decision. It wasn't even an issue, and I'm not so sure it is an issue. But that's something to keep in mind, is that underlying all of this, all of these privilege waivers, is also this idea of confidentiality. Now, what's really interesting to me is when I heard the introduction speaker, I think her name was Tori this afternoon, talk about how a disclosure affects or affected her, at least that's the way I took it, and how a disclosure of confidential information, whether it's under a privilege or not, that can affect our clients. And let me give you a real-world example that has nothing to do with GALs, but has to do with a criminal defense lawyer who represented a person who was charged with crimes, and the criminal defense lawyer talked to his client in the courtroom. It's a very common experience. You're in the courtroom, there's probably 30 other defendants and 2 or 3 DAs and a bunch of public defenders representing everybody who's coming up on the docket that day. The lawyer talked to his client about the crime, about the facts. And it wasn't the first time that he talked before, but sometimes you don't talk a lot to your client as a criminal defense lawyer, as those of you who have done that know, before you engage in discussions with the prosecution. The lawyer talked with his client and wrote down a lot of information about what the client was telling him. And then the lawyer went to the DA thinking, if I give this information to the DA, I'll get a better deal. So the lawyer went right to the DA and read off the sheet of paper on which he had been writing about what his client had just told him. And he never discussed with his client whether the client consented to that disclosure to the prosecution. And in fact, the DA interpreted that information differently than the defense attorney did, and interpreted it contrary to the defendant. It was prejudicial to the defendant and used it against him and gave him a much worse plea deal offer, a plea bargain offer, than the defense counsel anticipated. That attorney did he got sanctioned by the Supreme Court, by our office, after a hearing, I believe, for making that unauthorized disclosure. So the rule is very important, and it's very sacrosanct. And it comes from the duty of loyalty to our client. Okay. I don't know of an example in your area. Yes, sir.
Is all information obtained during representation confidential?
Yes. But you can, the question is all information obtained during the representation confidential? Yes. Even if some of it is in the public domain, even if the piece of information you learn is in the public domain, because the client expects you not to reveal that information. They expect a duty of loyalty from you. But you can disclose it if it's implicitly authorized to do so, and in order to carry out the representation. And so a lot of us get up in court and we say stuff that, the client expects us to say and wants us to say, and sometimes they may say, well, I didn't know you were going to say that, but it's implicitly authorized.
Is the expectation general to everybody or specific to the child thinking about a pre-verbal baby?
I'm not sure I understand your question.
What expectation does a pre-verbal baby have?
Well, the rule doesn't talk about expectation. This rule talks about information that the attorney learns. So if the pre-verbal baby has no expectation, it doesn't really matter. The lawyer has a duty of confidentiality to the lawyer's client. And if that client is the best interest of the baby, or the baby itself, separate from a GAL type of representation, then yeah, the information is confidential. So it's a big rule. I mean, I've talked about this rule many times in my career, and it always surprises me that there is a misunderstanding about confidentiality being limited to the attorney-client privilege, or maybe, in another little different context of the physician-patient privilege. As many people have said today, those are testimonial privileges. This is not a testimonial privilege. This covers everything the attorney learns, but there's also broad categories of consent, those which are implicit to carry out the representation. Yes, sir.
It says, unless the disclosure is impliedly authorized in order to carry out the representation. As guardians ad litem, we routinely make reports and recommendations at every court review. And we're authorized to do so under Chief Justice Directive. So my presumption, but I'd like your opinion, is that when we do so, we are likely doing so under that provision that it's impliedly authorized in order to carry out the representation.
Yes, that would be my opinion on those limited set of facts. Yep, you're doing the right thing when you make your thoughts known about the best interest of the child, for sure. Yes, sir. My good buddy Phil James, member of the ethics committee with me, is going to test me.
And here's my problem. Let's assume that I talk to the child. The child reveals information to me. Child is not my client. Gabriashevsky says that. And so I go to the court and I want to tell the court what it is that the child has said. When I started the dependency and neglect action, I didn't know anything about this child, the family, anything at all about them. And so what the child has just told me is something that I learned during the representation of the client.
Oh, but the client is the best interest of the child.
Right. So while I was representing the best interest of the minor child, I spoke to the child and the child told me this information.
Yes.
And 1.6 says that I may not reveal it without my client's permission, or one of the exceptions in B that you don't have up there which don't apply to this.
Right.
I can't, and you gave a silly little example of wearing different hats, and I don't think it's silly at all. I think that you can't get consent from the best interest of the minor child. In other words, I can't give myself consent to reveal the information because then it's unmanageable. Then I can give myself consent to reveal any information. And so it is entirely in my discretion. What that conclusion would lead to is the absurd result that it's entirely within my discretion as to what information to relieve to the court, which is no rule. The rule's gone. I have now eaten out the rule entirely. And that's my objection to whether, we talked before about some of the rules applying, some of them not. We agreed that 1.3 diligence applies, 1.4 communicating with the client does not apply because that's just silly. I think saying that 1.6 applies is another, that's just silly result.
Well, let me give you, I think you make an excellent point, and it is not a silly little example. It's a metaphysical example that we all have fun sort of thinking about and switching chairs in order to keep the roles straight. No, I understand completely. It's not silly at all because it highlights the schizophrenic nature of this representation in my mind. Not from a technical term of schizophrenia. But it seems to me that there could arise a circumstance where a GAL makes the decision that I'm going to disclose this and I'm authorized to do it in the best interest of the child, and then discloses so much more than is necessary to disclose in order to represent the best interest of the child. And there are other people watching that decision. And they may say, they may file a grievance with their office saying, it was great that Mr. Sudler revealed this piece of information, but he had no obligation, no right, it makes no sense for him to have talked about all this other stuff. And in fact, for him to make the conclusion that he needed to, that it was implicit in his representation, was absolutely wrong. And I don't know how that would play out, but I can imagine a situation where that could happen, where the GAL just discloses way too much, and the judgment in making that disclosure was not right. Okay, let's go on to the, okay, it's actually a little hard for me to see.
Yes. I'm actually sitting here kind of in horror a minute because I'm thinking to myself, all the information I learn sometimes when I'm interviewing caregivers, relatives, parents, whoever, and then I call the caseworker and I say, oh, guess what I learned today, and how do you think we should deal with it? And I'm sitting here thinking, wow, I probably shouldn't have revealed all that information. And not just to the court, I mean, I reveal information to the caseworker many times so that we can make joint decisions about things going on in the case.
In order for you to do your job as a lawyer, no matter whom you represent, there are times to investigate a case, you have to reveal information in order to find out information. And I think that's where the language is implicit in carrying out the representation to make that disclosure. Now, if it's something highly sensitive with not particularly, well, with a client who's not necessarily the best interest of the child, but if it's something very sensitive, you might want to have that discussion with your client before you disclose it to somebody else. But in our office, we have this problem all the time. Our investigations are confidential until a certain point, and we have to reveal information, confidential information, in order to find out what happened. And that's the same situation you're in. Yes, sir.
Isn't the point that Phil's making that you don't have a client like everybody else has a client? And if you don't have a client, how does this apply?
He's making that point, and I think he's doing a good job at it. the problem is, I think you do have a client, as you say, unlike any other kind of client, and you have to navigate the rule to make sure, in my thought, not to reveal too much. So that's going to be a judgment call, and you know, if let's say we got a request for investigation in our office that Phil revealed too much. He didn't have to reveal all that stuff, and he did. He revealed X plus 10, and he only needed to reveal X. We would probably get an outside expert GAL to tell us, what do you think? Because it would be really difficult for us to internally make that decision. But we'd talk to somebody else. And let me move on. There are some exceptions to, other exceptions to the disclosure rule, the lack of this, that you can't disclose things unless it's implicit. And these really don't apply, so I'm not going to spend too much time on them. Maybe to prevent reasonably certain death or substantial bodily harm, that could apply, I could see. But the other exceptions were really passed after the Enron scandal, and so it gives us permission to reveal things about our clients if it's going to cause some sort of financial harm or has caused financial harm. The last bullet point is very important for you all, I think. It says, you know, to comply with a court order or other law, you can make disclosures. So if, you know, if a judge is ordering you to disclose something, you can disclose it under this rule. Okay, let's keep going. So I've talked a lot about the differences between privileges and confidentiality, and I've got, you know, I think Ms. Calderon had the privileges up here, maybe the other panel did too, but it was just to point out, you know, these are statutory privileges that apply to testimonial situations, and there's the physician-patient privilege, and then the psychologist, counselor, or client privilege, and you probably have those already. And now we get to, of course, what we've already talked about. And this is, you know, the GAL represents the best interest of the child. And we know that, mainly now we know that from the Chief Justice Directive 0406, which was revised earlier this year. And as we've talked about, this is not a traditional attorney-client relationship with the child. But, interestingly enough, the opinion in Gabriashevsky, or I think in the Chief Justice Directive, says that all the other rules apply. Some of them can't apply, as it just doesn't make sense that they would apply. But the ones I think you have to be concerned about, and I'll talk a little bit more about this, are the diligence rule. You have to act diligently. You know, you cannot fail to do your investigation or visit the placement home in a diligent fashion. You have to do those in a timely manner. I'm not sure this is coming up a lot, that GALs aren't acting in a timely fashion anymore. Maybe it's an issue, but I don't remember us getting a lot of issues about this. We did earlier. Before this Chief Justice Directive, it was not a good situation. As far as I'm personally concerned, my personal contact with the dependency neglect cases, GALs, I don't think were doing their jobs as now is required under the Chief Justice Directive. And you have to understand, from my office's point of view, is we view this Chief Justice Directive as the law. I mean, if a GAL doesn't follow it, then the investigation is, why haven't you followed the rule of a tribunal? And that is a certain rule of the rules of professional conduct that says a lawyer must follow the rules of a tribunal, unless there's a good faith basis for not doing so, and there's an open refusal to do so. So if there's any doubt in your mind about the force of law of the Chief Justice Directive, I hope I've put that to rest. Is there any question about that? Do you know Mike Bender? Thank you. You know Mike Bender? Have you ever talked to him personally? How forceful he can be, and the flowery language he uses. I call him Mike, Chief Justice Bender. This is more respect. This is on tape. Sorry, Chief Justice. He's going to retire, so. And he said, did you read the article in the Post about what he said he's going to do? He's going to go back into criminal defense and rock and roll. I can't wait. So I want to talk a little bit about how the GAL should decide who holds the privilege, and it's been talked about a little bit. I don't think this issue has been talked about a lot, and that's the conflict of interest that may arise in this decision. Now, you may take the position that, as Ms. Dunbar was talking about earlier, let's just file a motion at the outset. Let's just get this. I'm going to file a motion to see who holds the privilege under land, and I'm going to get that decided right fast and clearly done. But what if that doesn't happen? And, or what if it's not ruled upon for a period of time? I don't know. But if it doesn't happen, I think you need to consider the conflicts of interest you as GAL may have in coming to a decision as to whether the child is the privilege holder. For instance, if you want to waive the privilege, if you want that privilege to be waived so that a particular report can be revealed to everybody because you think it's in the best interest of the child, but the child, as witnessed by the introductory speaker, the child thinks, I don't want that waived, I don't want that revealed or disclosed. Is your interest in getting it disclosed, is it somehow clouding your judgment before there's been an order in place? And I think that's important to remember, and it's important to consider. I think it's really good advice when I heard Ms. Dunbar say, just make that motion at the outset. Who holds the privilege? Now, of course, there are going to be gray areas in my mind. I heard today that 15 years old may be the cutoff. Well, what if there's a super precocious in the good sense of the word, precocious in the sense of understanding and having an idea of their own personal interest? What if there's a 13-year-old in that jurisdiction who may understand what's going on and may say, I don't want that revealed, but the jurisdiction has a 15-year-old presumption? I think you all have to be very careful in that situation to think, well, maybe we better make a motion to have an attorney appointed or for that child on this issue, or have the judge understand that this isn't a normal 15-year-old or 13-year-old. This child understands things better. I think you have to go through that thinking in your mind. Now, the decision to ask the court to appoint counsel to advise the child I think is a good one. I think you should be doing it in a lot of situations. To advise the child, if they're of an age to understand some kinds of legal advice, whether or not they should be making a waiver as contemplated by the land decision. Okay, let me keep going. I'm going to get to another issue that comes up in that situation. Determining who holds the privilege. So first of all, I think you want to ask yourself, is there a standing order in your district that assumes a child of a certain age retains the privilege, and is the child over that age or under that age? Make that determination. And does the order tell the GAO what to do? I mean, does it address ambiguous areas like I was just talking about, or no? And I think I'm a little bit concerned about some of the districts that have these orders. It makes me a little bit nervous about what could come down the pike, but I think that nervousness isn't so much in the ethics of the situations as it is just the situation and a child that may be of sound mind that may not be as old as the directive the district order has. What if the kid is over the age of the presumption in that district, but the GAL knows this kid doesn't have the capacity, doesn't have the competence to make this waiver? I think the GAL is obligated in a competency type of rule of professional conduct 1.1 requires us to give our client competent representation. I think the GAL is required to bring that to the attention of the court. Yes?
Something you were talking about earlier, Jamie, because I do think the GAO, because they are acting in the best interest of the child, could think something should be disclosed. And what if they then do get ordered to make that they're the one? I mean, is that when you tell the judge, no, because I need to see to make that decision or something?
I think that type of question is really going to be fact intensive, and we don't really have all.
I think that was the motivation of that GAL, as I understood it, was that they thought that information was important for the court to know in order to determine whether to terminate it or never. Let's assume that that's the fact situation. And yeah, it is saying something that the child said that didn't want to be revealed, but in order to protect this child, what the child said is important for the court to know. There's
Right. In that situation, I think it would be important to have made the motion to the court earlier to say, who has the privilege? Do I have the privilege, or does this I think she was 9 years old in the Land case. Does the 9-year-old have it? And get a clear order.
Okay, so you have a clear order that says it's you, but then you realize in making that decision, you're conflicted. Does that make sense?
No. Although it might.
You know, that I would sit there thinking, well, I don't live in that household, and you know, maybe this kid's going to get placed back in that household, and it is going to be intolerable. And yet, I think the court needs to know it because I don't think the kid should be in the household.
Mm-hmm. Well, I understand it's a conflict, but I'm not so sure it's a conflict that Rule 1.7 contemplates. I think it's a difficult decision that we all have to make when we represent a client. And I think in that situation, the GAL is essentially representing all interests of the client. Waiver of privilege, waiver of confidentiality, and best interest of the child. So I think it's going to be okay in that situation. The thing that Land does is it just throws another layer of, I'm not criticizing justice rights of the rest of the court. It's just, it's very difficult to analyze this situation. Like it leads exactly to this, well, am I conflicted in making the waiver decision that I actually have the legal power to make? So it's a very good question. It's a very difficult situation. Okay. So talking with the child, I'm addressing this not from the point, I don't know anything about what you all do except from what I learned from you all in getting ready for these things. So I'm talking about it from the point of view of a lawyer who does the rules of professional conduct every day. Should the GAL discuss the privilege of the child before the child has a separate lawyer? So let's envision a circumstance where the child is on the cusp, is there a better way to say it? Is on the verge of being able to make the privilege waiver him or herself, and you are the GAL, and you're not clear in your own mind whether they have the ability to make this decision. So you go talk to them to see what they say about the situation. I don't think there's anything that would stop you from having that conversation initially. In other words, you have the conversation about, we've got this doctor's report that says that X and Y are abusing you, and I think that this maybe should come to the attention of the court, and the kid says, no way. And then you might want to go through some sort of a set of questions to make sure the kid has understanding of the situation. And maybe you'll get to the point where you think the kid does have an understanding, and your next move is to have a lawyer appointed I would make a motion to the court to have a lawyer appointed for the child, to advise the child about their waiver of that privilege. And I wouldn't do it. I wouldn't reveal the report at that point. But you have to talk to the child. That brings up all sorts of problems, of course, talking to the child about this issue, because potentially you're not the privilege holder and they are, and potentially you are in conflict with the privilege holder. And therefore you have to be very careful about what you say, because you don't want to say to the kid at that point, you really need to waive this privilege, and if you don't, I will. Or something. You don't want to threaten them with it. You have to be very tender-footed around this issue, because they may get a lawyer, and the lawyer may decide it's not the right thing to do, and they may say, well, the kid may say to their new lawyer who's representing them, that GAL was pounding her fist and telling me to waive the privilege, and I don't want to do that. And then you might face some sort of problem with our office or the court. So it takes a great deal of sensitivity, I think, to have that conversation. But I do think you have to talk to the child about this. So how far should the child go? Do you explain all the consequences of waiver? You might. I mean, because if you explain the consequences of the waiver, you're simply explaining to them the downside of it. But you have to be very clear, I think, what those consequences are. And then the child, if the child is of age to have the privilege, it's himself, then I think you probably won't go too far, but you'll get a lawyer for them. If they're not, then I think you might have this discussion with them anyway. You might, yes, there's a question over here.
Yeah, I mean, one of the things that we all know we're required to do under this decision is consult with the child in an age-appropriate manner about the privilege and about what they do want and don't want. And obviously, you're right that you can't kind of say, well, you really have to do this. You really can't do that any more than a defense counsel can say, you really have to take this recommendation about, you know, this particular plea deal. But you might say, I'm going to recommend something to you. And I don't see that that's a wrong thing, and I think it's a reasonable part of consulting with the child on an age-appropriate basis.
Excellent. I don't disagree with what you said. I hope I didn't say something that was 180 degrees different. It may have been 10 or 15 degrees off. But, you know, I've heard lots of criminal defense lawyers yell and scream at their clients.
Well, I hope they aren't saying you have to take the plea deal.
Oh, I think some of them do. I think some of them do. I think the next sentence is, or I'll withdraw. Things like that. And you won't get any money back. Okay. So let's say the GAL is the holder of the privilege. The child is too young, right? I just want to make this rather basic here. The child is too young, can't make the decision about the privilege. And, or the child is not too young, but just otherwise incompetent to be the holder of the privilege. But of course, as was earlier said, you know, the parent then may be the default. Now the question is the parent, and of course in the Land case, the parent was a party that might have an incentive to waive the child's privilege, which wasn't in the child's best interest. But it was really interesting to me to hear the panel earlier today talk about there may be somebody else that should be a holder of the privilege before the GAL. And I thought the checklist that Ms. Dunbar gave off of first it's the child, second it's the parent of the child, third it may be somebody else. Somebody, a relative or somebody taking care of the child, it could be that person. And then fourth is the GAL. That was really interesting for me to hear. And, but I think that's important for you to remember. There is a hierarchy or a lowerarchy or whatever you want to call it of people who could serve in this function. Now, assuming the GAL holds the privilege and is going to make the decision whether to waive it or not, the ethical rules that come up in my mind are mainly the competence rule, and another one in a moment. The 1.1, you know, we have to render competent advice to our clients, and our client in this case is the best interest of the child, and it has to be a competent decision. And Phil and I were having this discussion just a few minutes ago about the decision to waive it must be done competently. And what do you need to disclose? Is it the entire doctor's report or not? Can you disclose it the way Lan apparently talks about? I'm not sure I understand exactly what Justice Rice was talking about. You disclose what the doctor said or something without disclosing the whole report. I'm not so sure that works, but it certainly appears to be from that decision that it might work. But you have to make a decision. How much do I have to waive? That's also a competence decision. And keep that privilege log. Now, if you're not doing that, it's important, you know, for you to do that, to keep the privilege log. Judge Greenacre was talking about that. And if you're not familiar with privilege logs, I urge you to do some research into the area and civil litigation disclosure about how they do it. We do it in our office in certain cases. In this recent Arizona case I did, which involved 25,000 pieces of paper, we had a privilege log and we kept it dutifully. And it's a pain in the rear end, no question about it. But if you keep the privilege log as the case, as you start and all through it, I'm not turning this over, and here it is. It's the letter from me to the doctor. It's the letter from the doctor to me, dated such and such. Then, if you keep it up to date, you're gonna do a good job. You're gonna be doing your diligent work competently. And be cognizant of what you're not waiving. Why am I not waiving this, and why is it important that I not? Because you may be asked at some point, either a privilege log or some description of what you're not waiving. What interview notes aren't you waiving? Things like that. So be cognizant. Be aware. 1.6 we talked about. Don't waive more than is necessary for the purposes of the disclosure. Conflicts. When you disclose. Well, let me back up here. Let me go to the last bullet point, because this gives some illustration to this issue. We have done investigations in my office where it was clear that either the GAL or a respondent parent was taking action because they were just so angry, to use a polite word, at the department of what the county or the department or whoever, or a person in that agency, and it just got out of hand. And that raises the 1.7 conflicts issue, because the lawyer is taking action which is motivated by the lawyer's personal animus against somebody else, not because it helps the child or the respondent parent. And it just turned into fights between the court then and the lawyer who is taking the inappropriate action, and it ended up in our office. And it also has led to lawyers forum shopping. I've seen forum shopping from a dependency neglect case, and the same lawyer, because they're so angry at the department, will file a parenting action in a different county and try to get and there's a statute that covers that. I know that, and so we had to point that out to the lawyer involved. But you have to make sure that your motivation is not to frustrate or embarrass or to retaliate against somebody. You're not doing something because you just don't like that social services worker or whoever they are, or that expert. And I think that can come up, and it has come up. Also, you don't want to do something just to harm somebody, right? To punish somebody because they're not a good parent. Okay, I don't think I need to say too much about that. It probably is self-evident. Diligence, as I said earlier, I don't think we're getting a lot of cases where it's alleged a GAL or even a respondent parent is not acting diligently. But just be aware, it's a very important rule that you act diligently. You make deadlines, you pass on deadlines. Of course, a respondent parent counsel is going to have to communicate. 1.4, that's another rule Phil and I were talking about. 1.4 is the communication rule. It requires that the lawyer communicate well with their client and tell the client about all of the things that are going on in the case. Now, from a GAL's point of view, you really don't have a client to have that communication with, right? Unless you do the silly example of the two chairs. But you might do that with a child anyway, even though it might not be legally an obligation under Rule 1.4. So let's assume that you are an attorney who is appointed to represent a child who has the competence and the capacity to make the decision whether or not to waive a privilege. If it's a physician privilege, a psychologist privilege, maybe a prior attorney privilege. For some reason, it raises its head in a matter. The kid had a prior attorney, or the kid had an attorney in a criminal proceeding, or juvenile delinquency proceeding. GAL cannot make the decision to waive a privilege. The GAL thinks the child should waive, and the attorney is appointed to advise the child about this situation. Well, the first thing I want to say about this, the attorney who's appointed in this particular matter to represent the child needs to make sure that the order appointing him or her is clear or as clear as the lawyer wants it to be. I would want it to be very clear. Am I representing the child for this limited scope to advise the child about whether to waive the privilege in this situation? If that's not the scope of the order, is that attorney being appointed to represent the child in the proceeding as opposed to the best interest of the child? And I don't know if that's happening. Is that happening? Where somebody in a dependency neglect case has a GAL and a lawyer representing the child? Too new. Too new. Well, it's going to come up, I bet, right? So, but for the lawyer who's advising the child about the waiver of the privilege, I think you want to make sure the order is clear. That is your limited scope. Now, one of the ways that will protect you, because then somebody can't file a grievance against you, or somebody can't file a malpractice action against you saying, you did that waiver advice, but you did not do everything else that we thought you should have. Well, I didn't do it because the order says I was limited to this scope. Okay. Now, advising the child fully about the waiver and the consequences of the waiver are important. And it may not be that important. I mean, you may not have to do much of an advice on this, but the lawyer advising the kid whether or not to waive the privilege should go through each aspect of that waiver, each aspect of what is it that they want you to waive, and how can that affect you? Is it going to ruin, or that's probably the wrong word, is it going to lead to the termination of your parental relationship forever? Or could it? Or how is it going to affect the people involved in your life if this information comes out? So you want to make sure that you fully advise, like any client, you fully advise them of the consequences of their action and their rights, whether or not they have to waive the privilege. And you might want to have a conversation about, what did you say? I mean, is there something else here that you said? And see, in this context of that attorney-client relationship, anything that kid tells you, you have to keep confidential under 1.6, unless you're ordered by the court to reveal it. But I don't think that would happen in this situation. But so the kid can tell you everything about what happened with the therapist. The kid can tell you everything that happened with the parent. And you have no obligation to reveal that. In fact, that's sacrosanct, so you shouldn't never reveal it. So that's what I would do. I would get to the bottom of the issue with the child by going into everything that happened with the child and whether or not the child should waive it. And it's ultimately the child's choice. Okay. Okay, so when you're talking to a therapist or you're talking to a doctor, whether you're a GAL or an attorney for the kid or a respondent parent counsel, you always have to be very careful that the person you're talking to understands who you are. And this has come up in our office, that the lawyer representing one of the parties in a dependency neglect case will called a physician, I'll speak of it the way it happened, called a physician who was treating the mother in a dependency neglect case. And the lawyer did not make it clear whom she represented. She represented the father in the dependency neglect case. But so she's calling the doctor who treated the mother. And she gets a lot of information from the doctor about the doctor's patient, which is clearly confidential and privileged. And clearly the doctor should have been a little bit more on her guard to determine who she was talking to, but she wasn't. But after about 5 to 8 minutes of questions by this lawyer, the light went off in the doctor's head. Hey, wait a minute, these questions are coming from somebody who's representing the father and or not really looking out for the interests of my patient, the mother. And the doctor said, who do you represent? Now that obligation, maybe the doctor has an obligation to do that, but the lawyer has an obligation to make it clear to the doctor whom the lawyer represents. And if the lawyer has any sort of clear indication that there's a misunderstanding, the lawyer has to clear it up. And that lawyer got a public censure for that, no, private censure for that conduct, in addition to other conduct, misconduct. It wasn't the other conduct. None of it was very serious in terms of attorney ethics, very serious in terms of confidentiality of doctor-patient privileged information. So you have to be very cognizant of whom you're talking to and what they understand your role in the matter. Okay, child holds privilege, but there is no attorney. For some reason, there's no attorney appointed for the child, but the child holds the privilege. And maybe the child rejects counsel. Maybe the child says, you can appoint counsel for me, but like some criminal defendants, you know, they say, get out of here. I don't trust anybody. I'm not talking to you. Get out of here. So you have to talk to the child in this situation. Once again, you have to be very careful, right? And this is a little bit what we were talking about earlier. Your obligation to talk to the child. You have to talk to the child about some of this stuff. But, you know, you have to be very careful to explain what you're talking to them about and why you're talking to them and your role in the situation. That your role isn't necessarily to represent what they want as a person, but what's in their best interest. You've done this before, so. But I'm just saying there are situations that might come up where there's no attorney appointed for the child, but they are competent to waive the privilege, but you have to talk to them about it. So be careful. Okay, so one of the questions that came up recently from Linda was this issue, and it's a successive representation. Let's say the lawyer represents a child as a GAL and then is later appointed as a child legal representative in another matter. My view of this, unless you can give me some facts that change this general situation, is that there's no conflict here, because both roles are to represent the best interest of the child. And so that's the same role. It's the same essential client. And so I don't see any problem in that successive relationship. Okay. And then a situation may come up where other people ask the GAL for information, maybe an immigration lawyer who asks for information in order to carry out some sort of an immigration proceeding involving the child. Or the lawyer asks for evaluation about the child or a parent. These are difficult questions to answer generally. I think anytime a lawyer whose representation has been terminated appropriately, I mean, at the end of the GAL appointment, and somebody else is calling you for information, I think the first step for any lawyer is to contact their client. And maybe the child is now of an age where they can make the decision on their own whether or not to consent to your disclosure of the information. Maybe they're not, but the problem I have with this type of scenario is that the GAL's appointment is over. And so I don't know what I would do. I really don't know what I would do. Has anybody encountered this situation? Yes, sir.
I think a common situation is I'm a GAL for a child in Denver, case closes, family moves. So I'm a former GAL for a child in Denver, case closes, family moves, it's refiled now in Boulder. I get a call from the Boulder GAL. I've been appointed to this case. I see that you were, GAL before. What do I need to know?
Has anybody encountered this? What did you do? I mean, I really don't know the answer to this, other than it makes me a little bit nervous. He's giving the mic back. he's now left the room. I don't know what to tell you to do. I would talk to my client. Let's put it in the context of a regular attorney-client relationship where you weren't a GAL. You represented somebody in a dispute, you were terminated, they went and got new counsel, and new counsel wants the client's file. I would call my client and say, is it okay? And most clients will say yes. But what do you do when you're a GAL? Do you say, I don't know if it's in the best interest of the child, but I'm going to make the conclusion that it is the best interest of the child, and I'm going to give the file to the successor lawyer. I guess that'd probably be okay. But because you're both representing the best interest of the child. I don't know if I'd give it to anybody else, though. If a doctor calls, says, I want all your notes, or if the respondent parent counsel calls, I wouldn't give that up. Not without some sort of a consent by a client or order by a court. I just wouldn't do it. It just makes me nervous. And my job here is to make you nervous. Any other questions? Any other? Yes, Terry.
Foresee a situation where we had I don't think that, oh, it is, yes, okay. Where we were representing best interests, talked to our client about disclosing information. The client said no. We asked OCR to pay for appointment of somebody to advise about the waiver. So we felt like the client was fully advised. But we get to termination, and my position is that this relationship needs to be terminated, and it's highly unlikely without the testimony and the records and the information. So, thinking about what's confidential, what's not confidential, and I feel like I'm in a position where I have to disclose it all, or my position will not prevail.
Why? Okay, I'm trying to figure out how come you think it needs to be disclosed? Otherwise, something that won't happen. What won't happen?
Often our cases, often the information that therapists have about what's going on between the child and the relationship of the parents is the crux of why a child shouldn't see a parent, that visitation is damaging, that the relationship is harmful, that it should be terminated. So that's what I'm sort of anticipating, and thinking about all this being confidential and being so adverse to what our best interest client wants us to do, feels very uncomfortable.
It feels uncomfortable because you're afraid the court will make a decision not based on all the information.
Correct.
Yes, but I think that gets back to what Ms. Dunbar said, is like your job is to do your job as best you can. And if the kid and the kid's lawyer are not waiving the privilege, then that's out of your control in that situation.
So I just disclose what I have, and I call the therapist, and I do whatever I can do to put all that information out, regardless of who has the waiver or who doesn't.
But you can't put that information out unless you have.
That's what I'm saying. To do my job, I have to.
But I think your job has been redefined since LAN. That's I think what's happened. From my perspective, since LAN, if a kid holds, I keep saying a kid, I don't know if that's politically correct or not. If a kid holds the privilege, then that puts a whole new twist on what GALs used to do, and from my perspective, and that has changed the playing field, the baseball diamond. It's changed the situation you're in. It's added another layer of complexity, and it means that if you think that the kid's rights or the parents' rights should be terminated, and that's not going to happen, it's one of those things that we somehow have to learn to live with.
I'll just chime in there too, Terry, because I do think, though, that sometimes we rely too heavily on the therapist and the therapist opinion. And termination is a creature of statute, right? There are specific statutory criteria, and I'd submit to you that you can get a lot of that information from other sources. You don't have to rely strictly on the therapist and what the therapist is finding, right? You can look at how that kid is adjusted to the foster parent, to the grandma, what they're doing in school, what the compliance with the treatment plan has been, what objective changes people have seen in terms of visitation. And you can make your termination case without that therapy piece. So.
Well, I think there are cases where I would respectfully disagree.
Yeah, no, and I think there are, but I think oftentimes we overlook other sources of information because we come to rely on one-stop shopping with the therapist. That's all I'm saying.
Linda, wouldn't you say if the child's, because this is a classic example, if the child's therapist has already given the GAL the information, can't we, in a sense, argue that the child waived their privilege?
That's a really tough question for me to answer, because I think the holder of the privilege is the child. We start off from that premise. The therapist cannot waive that privilege. It's like the attorney-client privilege. The attorney cannot waive the attorney-client privilege. The client is the only one who can. So just by the fact that the therapist gives you the information may not answer that question. And I think that in that circumstance, if you think there's ambiguity about whether it's been waived, I think you bring it to the attention of the court. I don't know if I have the authority to disclose what I have in my possession, which is sealed, until you tell me otherwise. I don't know, are there other views about that? I can point, but I don't have the mic.
It's like critical information as to how the therapeutic relationship is going. Okay, it can make or break. It can make or break kind of the course or direction of the child's life. If that therapy is ineffective, something needs to change. So as a guardian ad litem, I see it as very important to ask the question of the child. Maybe don't get into confidential communications, certainly not that. But if you don't ask the question, how's your therapy going? Is it helping you? Is it, you're not going to get the answer to probably one of the most important questions in the case. So I'd like to suggest that if we're going to get tangled up in this, that we really have to be careful that we don't miss one of the big questions that a child could affect the child's life. So the question is, how do you get that information? And I mentioned earlier, court-ordered evaluations. You can have a court-ordered evaluation of whether that therapy is working or is effective. And I think, would you silently stay away from the therapeutic relationship, or do you actually have some responsibility there?
I really think that's a good point about evaluations, and Linda made it, and you made it. Get another evaluation. Ask the court. I'm not sure. I don't understand what's going on here. Is an evaluation to find out if the therapy is helpful or not. So I would be very leery of asking the kid, "Hey, what did you tell your therapist?" You wouldn't want to ask that question.
Okay. Isn't this an ethical problem that was just pointed out? If you get information from a therapist and you know your child has not waived the privilege and they're the privilege holder, you shouldn't have that information. And I don't think you should be making any decisions about what to do about getting evaluations or anything else based on that information, because you shouldn't have it. You better not share it. Am I right or wrong?
I think you're absolutely right. I think I don't think I had clearly concluded that the information was privileged. I hadn't gotten as far as you went. No, you should never use it. No, unless you find out. I would ask the court. I have this report. I don't think I should. Maybe I shouldn't have it because the therapist gave it to me. I don't know if the kid waived the privilege. Please let me know whether or not this privilege has been waived. And don't use it. But an evaluation, I was thinking about an evaluation based upon other information. Susan.
Well, what happens if at the beginning of the case the parent holds the privilege, waives the privilege, you get the information, if something comes out that they decide that the parent is conflicted and somebody else then has the privilege, and then you go here. Can you use the information you got that was waived?
If it was waived at the time, at the time it was shared with you, I mean, I'm sorry.
I defer to Linda Wiener. Could you repeat the question?
Oh, sorry.
Hold the mic. I can't hear the mic.
Yeah, just repeat the question. If you got it from somewhere else.
Oh, I'm sorry. You wanted to know the question. The question was if somebody was deemed the privilege holder, the parent, let's say, and the parent agreed to waive information, and you obtained that information after the privilege holder waived it, and then subsequently another party was determined to be the privilege holder who said, oh, I don't want to wait. Can you legitimately use the information that you had learned with the initial waiver by the legitimate privilege holder? And the answer was yes.
Yes. Okay, well, I don't think there are any, I can't see any more questions, and I can't really see you all very well anyway, so.
Jamie, thank you so very much.
Thank you.